One of our largest practice areas is representing clients on franchise issues, including franchise litigation. COVID has put additional pressure on the franchise businesses, and we have two very experienced partners from our Washington, D.C. office virtually here with us today, Mesa Frank and Michael Sturm. Mesa and Michael, I'll turn it over to you all.
Thanks very much, Jean Paula. We're very excited to be here to talk to you today about franchise litigation. And because we're new to this program, we wanted to start by sort of just giving you an overview of the laws that govern franchises. And then we'll discuss some common claims that arise, in and out of the franchise relationship. And at the end, we'll touch on a few sort of COVID-related issues in the franchise context. So I'm Mesa Frank. I am a litigator in the Franchise and Distribution Practice Group out of Washington, D.C. I represent franchisors in all types of litigation proceedings, and with regard to virtually any type of dispute that might arise out of the franchise relationship. And on a personal note, I have settled in well to the work-at-home environment, but my work-at-home colleagues include a 4-year-old and a 2-year-old. And although they're very fun, they're not the most polite office mates. Michael?
Good afternoon, everybody. My name is Michael Sturm. You see my bio up there on the screen. But in addition to that, I joined the Franchise and Distribution Group at Great Plant Moody about 2 years ago. And at that time, our group was split pretty evenly between the Minneapolis and DC offices. One of the benefits of this merger to form Lathrop GPM is that we have added new members of our group in St. Louis. So we now have over 30 lawyers working primarily on franchise issues. We also have been able to work with our colleagues in other offices, including in California, which, as I will discuss, is a real hotbed of both franchise litigation and regulation. Let's move to the next slide, please. So in looking over the attendee list while we were preparing for this presentation, we noticed that a lot of the people who are listening are not franchise lawyers. So as Mesa said, we wanted to start by giving you a framework to give you a sense of the kind of issues that we typically address. So everybody has a common sense understanding of what a franchise is, but legally there are basically 3 elements, which are the franchisee operates a business under the franchisor's mark. The franchisee uses a marketing plan or a system that is controlled by the franchisor. And third, the franchisee pays a franchise fee, which can be an upfront fee or a royalty on sales or potentially a product market, sometimes a combination of the 3. So those 3 elements are not all that demanding. It is very easy for distribution agreements to slip into a mode where they will be considered franchises and subject to all the kinds of regulation that I'll discuss and that Mesa will discuss. And one of the things that our transactional team does in particular is to try to structure deals where possible to avoid all of this regulation. In an ideal world, there are benefits to a franchise relationship from both sides. For the franchisor, it can expand quickly using other people's capital. It also has highly motivated operators because they have equity in the business. From the franchisee perspective, they aren't starting from scratch and they have the benefit of the franchisor's established marks and goodwill and system. On the other hand, we are litigators, so we're typically not dealing with the ideal world. And there are some economic and both economic and non-economic issues that sort of come up repeatedly in the relationship. On the economic side, franchisor revenue may come mostly from royalties on gross sales. So the more units you have, the more volume you have, the more total sales, the better the franchisor does. On the other hand, the franchisee most typically is more focused on the net profits of each unit. The franchisor also wants its system to be as uniform as possible, whereas franchisees consider themselves to be, and they really are, independent business people and entrepreneurs, and they're also on the ground at a particular location. And so they may chafe under the franchisor's desire for control and uniformity. I mean, depending on one's perspective, it's either innovation or it's failing to comply with the system. And that's a recurrent stress in the franchise world. Let's move on to the next slide, please. So contracts are obviously preeminent in our industry. That's probably not unusual. But other than that, there's a very somewhat unique regulatory structure. And there's a very odd mix of sort of federal and state regulation, particularly when you consider the fact that most franchisors either are or they're planning to be substantial participants in interstate commerce. So let's move on to next slide, please. Okay, so I'm going to follow the supremacy clause and start with federal regulation. So the first thing to know about is the FTC rule, which was enacted in 1979, substantially amended in 2007. It requires a pre-sale disclosure in a specified form. So it used to be known as an offering circular, now it's known as an FDD. It's similar to a securities prospectus in many respects, has a list of items and a required disclosure for each of them. But the FTC doesn't review FDDs, and it is also not an active regulator of franchisors. So in that respect, there's a rule out there, but it's nothing like, say, the SEC in regulating securities offering. Trademark law, federal trademark law is also important for obvious reasons. It tends not to be very controversial because our clients typically, have, registered marks and often very famous marks that get additional protection, and the Lanham Act gives very substantial rights to mark holders. Third body of federal law that's important is the antitrust law. Franchisors and franchisees alike may want allocated territories. The franchisor may want to control pricing of units so it has uniform pricing, either advertised pricing under Colgate or possibly more directly. And the Supreme Court has vastly expanded the power to do that by making first vertical non-price restraints subject to the rule of reason, and then even price restraints subject to the rule of reason when they're in a vertical agreement like a franchise agreement. So they are now all subject to the rule of reason rather than being per se illegal. And that has vastly expanded potential franchisor control of pricing and territories and basically all aspects of the franchise relationship without the significant danger of running afoul of the federal antitrust laws. Then the fourth significant body of federal law is the Federal Arbitration Act that Brian just touched on. A lot of franchisors include arbitration provisions in their agreements. Some don't. This is always a very hotly debated topic within franchise systems. If they are included, and it's hotly debated among franchise lawyers, whether it's beneficial or harmful, but if an arbitration provision is included, the FAA is very helpful in enforcing it. Let's move to the next slide, please. Okay, this is state law. The key thing to know here is there is really tremendous, and I think possibly unprecedented variability in the extent to which states regulate the franchise relationship. It's not like the insurance industry or some others where every state regulates. There's a full continuum from one extreme to the other. In California and some other states, regulation is pervasive, pre-sale regulation is pervasive, and enforcement is very rigorous. Others are completely hands-off. There are 15 states approximately that require registration of the FDDs that I mentioned earlier. Some will review the FDD with a fine-tooth comb. They'll review the proposed franchise agreement and require changes before allowing a sale. So it's, I think, pretty unusual for a state to be reviewing contracts before they're offered or go into force. Some enforce as a required state-specific addendum, and generally look over the franchise agreements very closely. A large part of our transactional group in all three offices is experienced in dealing with these regulators and getting these registrations approved. Second state of laws is the relationship laws that govern the ongoing relationship. Most states don't have them, but the 21 that do are sort of all over the map in terms of what they require and prohibit. But what's interesting is that you may be operating a nationwide system, but under a form agreement, but the parties' rights under those agreements may vary very significantly depending on what state you're in. And for example, the restriction may be fairly simple to deal with. Say you have to give 30 days notice prior to termination rather than 10 in the contract or something like that. But some states impose very substantive requirements. So, for example, New Jersey, which says if you want to, you may have an agreement that lasts 10 years, but you still can't renew it unless the franchisee has breached the agreement if it's subject to the act. And that's unusual, but it's indicative of the kind of agreements that are out there. So now we're ready for our polling question. If you could pop that up, please. All right, there it is. So just for background, this concerns anti-poaching provisions. And what these are is provisions in franchise agreements that basically say one franchisee can't hire away another franchisee's employees, or managers without consent. And they have become very common in franchise agreements. We've sort of done the 50-50 approach from Who Wants to Be a Millionaire. So you just have to choose one or the other here. And do we have results that we can pop up yet? So this is very interesting because so 81% says it's DOJ, 19% say it's the Washington Attorney General, and actually the correct answer is the Washington State Attorney General. Now you may say, if in my con law class we spent weeks and weeks talking about the Dormant Commerce Clause and only a week or two about talking about the First Amendment. So I find the Dormant Commerce Clause very interesting. You may wonder, how is it possible that the Washington State Attorney General can regulate contracts between, say, a franchisor in Chicago and a franchisee in Maine, but he has asserted that authority and has been very successful in forcing franchisors on a nationwide basis to change their agreements to essentially eliminate these provisions. The DOJ, on the other hand, has taken the position that these agreements are subject to the rule of reason, and while they're not per se lawful, they are likely to be found lawful under the rule of reason. There are a bunch of class actions that are seeking damages for past anti-poaching provisions, and these probably would have been among the biggest news in our industry, except for everything that's going on in COVID right now, because at least two of them are in the class certification phase that Brian mentioned earlier is key. And so it'll be very interesting to see how those turn out. And now let's go to the next slide, and I will turn it over to my partner, Mesa Frank.
All right, thank you, Michael. So with that background now, I'm just going to discuss at a very high level some of the common substantive claims that arise in the franchise context. And there is a lot to cover here, so bear with me, and please reach out to us if you have any questions or you want more detail about anything. We've broken this section down into sort of 3 buckets: claims that a franchisor might have against a franchisee, claims that a franchisee might have against a franchisor, and then claims that involve third parties. So with regard to claims that a franchisor might bring, the first main type of claim is going to be breach of contract, and that just will arise from a violation of a provision in the franchise agreement. There are a few common types of breaches. The first is non-payment. So as Michael alluded to, the franchise agreement is usually structured such that the franchisee pays royalties based on a percentage of the gross sales of their unit. So and then there might be other recurring fees that are required too, such as fees that go to a common advertising fund, or fees for the use of technology or something like that. So if the franchisee fails to pay these required fees, that will be a pretty straightforward breach of the franchise agreement. The next common bucket of breach of contract claims are what I term here non-compliance with system standards. So what your system standards are, of course, will depend on the type of business that you're running. But for example, if the business is selling food products, non-compliance with system standards might look like using unapproved ingredients. Or this could look like the franchisee not operating during the required hours, or not complying with health and safety requirements, or for example, in the retail setting, a franchisee offering unapproved promotions. All of those probably run afoul of the system standards. Standards are sometimes found in the franchise agreement, but they are often found in an operations manual that a franchisor typically gives to the franchisee at the outset of the relationship. And the franchise agreement will usually have a provision that makes compliance with the standards in the operation manual required under the franchise agreement. So that would be your breach of contract hook. These types of violations typically come with some sort of cure period. So if a franchisee fails to comply with one of these standards, they'll typically have some amount of time during which they can remediate that breach. But if they don't do so within the specified time period, then they'll be in breach of contract. And then the last type of claim I just wanted to briefly mention is what I call fraudulent conduct. And this is sort of separate from a common law fraud claim, which might also exist, but there are certain types of conduct between a franchisor and a franchisee, given the fact that this is usually an ongoing business relationship. Certain conduct that sort of erodes the trust between the parties. The franchise agreement will often contain provisions that prohibit that type of conduct. An example might be under reporting of sales. So as we said, the level of gross sales is often used to calculate royalties. And so, if a franchisee wanted to sort of report less sales than it had, and in order to avoid royalty payments to the franchisor, that would obviously cause the franchisor damages, but it also is the type of fraudulent conduct between the parties that is often going to be a breach of contract as well. So a lot of times in the franchise relationship, you'll have these breach of contract claims, and those breaches of contract typically give rise to a right to terminate the franchise agreement, after the appropriate notice and whatever cure period is applicable. And if you've terminated the franchise agreement, but you're in litigation, it's probably because the franchisee did not accept that termination, but is contesting it, and often is continuing to operate as if the franchise agreement is still in place. So that would give rise to a situation that we would call a holdover franchisee. And if you have a holdover franchisee, you probably also have a claim under the Lanham Act. As Michael said, the Lanham Act gives rise to things like trademark infringement, trade dress infringement, unfair competition. And courts have regularly found that when a terminated franchisee continues using former franchisor's trademarks or service marks or trade dress, then there is, a strong risk of customer confusion about, sort of the origin of the services or products provided. And, since the franchisee is no longer licensed to provide those services under the agreement. And so you will have a Lanham Act claim there as well. On the next slide, I just wanted to briefly discuss the final kind of issue that might arise, from the franchisor side, and that is the enforcement of restrictive covenants. Most franchise agreements contain an interim covenant not to compete, and many of them also contain a post-termination non-compete. So the interim non-compete would prevent a franchisee, from engaging in a competitive business during the term of the franchise agreement. Those are, generally enforceable as long as what constitutes a competitive business is appropriately defined. They're not, subject to the same level of scrutiny as a post-termination non-compete is. On the other hand, in order to be enforceable, a post-termination non-compete needs to be reasonable in duration, the geographic scope where the activities will be prohibited, and then also the scope of the activities that are restrained by the covenant. Post-term non-competes are governed by state law. Restrictive covenants are governed by state law, and the differences in state law make this a very kind of broad and nuanced topic. But I think it's fair to say in the franchise context, in general, post-term non-competes can be enforced if they're reasonable in duration, geography, and the scope of the activities restrained, probably with the notable exception of California, where it's very difficult, if not impossible, to enforce these types of covenants. The important thing to remember here is that you need to look at, whatever law governs the covenant, so that, if your contract has a choice of law provision, that law might apply, but you also need to look at the law and the public policy of the state where the franchisee is located, because that, state will also have an interest. Moving to the next slide, I have listed here a few of the common claims that a franchisee might have against a franchisor. The first set of these relate to those statutes that Michael talked about. So as he mentioned, the FTC and some state agencies have promulgated regulations that require a franchisor to disclose certain types of information to a prospective franchisee before selling a franchise. And some of the states also require the franchisor to register with that state before they sell the franchise. So, if you are selling franchises and you haven't done that, then you have possibly run afoul of this law. We see this issue pop up sometimes in situations that we call accidental franchises. So it's important to remember that if you have a business agreement and it contains the elements that Michael discussed, meaning you have the right to use a trademark and there's some sort of business system or marketing plan or control, and there's a fee, then you are a franchise regardless of the intent of the parties and regardless of what you title the agreement. So you can call it a license agreement, or you can call it a joint venture or something like that. But if you meet the definitional elements of a franchise, then you are one. And if you are in one of these states that requires certain disclosures or requires you to register, then you need to do that. It's also worth noting some states have what are called business opportunity laws. These are often, very similar to state franchise laws. Some states have unfair and deceptive trade practices acts that govern the franchise relationship. And then there's another type of state law called, we term them little FTC acts. And these are states that essentially adopt the FTC franchise rules. So there is no private right to action under the FTC franchise rule, but some states by statute have created a private right of action under state law for violating essentially the FTC rule. And then the last type of claim here are violations of the state relationship laws. So, like Michael said, those laws govern the relationship between franchisors and franchisees after the franchise agreement is executed. We see violations come up frequently in the termination or non-renewal context. Some of these statutes require good cause to terminate or not renew a franchise agreement. And, they sometimes enumerate what constitutes good cause, but you need to comply, with the statutes. And then some of them also have a required notice or cure period before you can terminate a franchise. The important thing to keep in mind here is that the law that applies is generally going to be the law of the state where the franchise is located, or the law of the state where the franchisee is a resident, because the purpose of these laws are generally to protect, residents of the state that has adopted them. And in some cases, you are not able to contract away the protections of a franchise statute by, for example, choosing a different state's law to govern your contract. So you do really need to look at the relationship laws in the state where the franchise is located, if there are any. Really quickly, I wanted to talk about two other types of claims. The first are sort of in the fraud or misrepresentation genre. A lot of times these claims are going to come up related to representations that were made during the process of selling a franchise. So there might be common law fraud claims, but there also could be statutory claims. Some state franchise statutes contain anti-fraud provisions that will prohibit a franchisor from making a misrepresentation during the franchise sales process, or they might prohibit a franchisor from omitting information that is required to make a statement not misleading. And that might also apply to statements made in the franchise disclosure document itself. So this sometimes arises with regard to financial performance representations, which are also known as earnings claims. Usually in a financial performance representation, which typically gives sort of the past performance of a franchise unit, of all franchise units or a certain subset of franchised units. Those are permitted, but if they are made, they must be made in item 19 of the FDD. And that's obviously going to be one of the most important pieces of information that a franchisee gets. So, there are sometimes allegations that, the earnings claims themselves are misleading or fraudulent. And there might also be allegations that they were just made outside of the FDD. And then the last type of claim here is breach of contract or breach of the implied covenant of good faith and fair dealing. It's pretty self-explanatory. The franchisor, might also breach provisions of the franchise agreement. On the next slide, I have listed some types of claims that arise in the third-party context. I don't want to spend too much time talking about these especially because we're running short, but I just want to note that there might be claims brought by third parties, either, in the vicarious liability context, which might, for example, involve a customer, that slips and falls in a franchised unit and, is trying to hold both the franchisee and the franchisor liable. Or in the joint employer claims, those might, be brought by, say, an employee of the franchisee who, is trying to allege some employment law violation against both the franchisee and the franchisor as a joint employer. In both cases, the franchisor is probably going to argue that they don't, have the requisite control over, whatever caused the harm or over the employment practices or, whatever to be liable. So I guess now would be a good time to just move on to our next slide where we can talk really quickly about some COVID-related issues.
Okay, and I'll start with these. And this one isn't on the slide, but there was an interesting decision recently in the District of Arizona in a case brought by Exponential Fitness, which is a franchisor of multiple different fitness concepts, and it was challenging the governor's shutdown order and asserted various mostly constitutional related theories such as substantive and procedural due process, contract clause, etc. The court found that it was unlikely to succeed on the merits. Not surprisingly, the court gave a very deferential, rational basis review of the governor's decision and denied the preliminary injunction on the basis that the plaintiff was not likely to succeed on the merits. It also looked at the balancing issue and said, well, there's important issues on both sides, so it couldn't decide it on that basis, but it did decide on the likelihood of success prong. There's also a case, the McDonald's case that's referenced there. It's pending in Cook County Chancery Court, and the name is Massey versus McDonald's. And it's a mass action of a number of franchisee employees, and they sued both McDonald's and the franchisees, asserting that franchisees were not complying with all of the governor's restrictions on social distancing and masks and things like that. Court found that McDonald's was not liable because it did not and wasn't subject to injunctive relief because it didn't operate any restaurants itself. It didn't consider the control issues that Mesa just addressed. But it did find that some of the franchisees were not complying with some aspects of the order and required the franchisees to do so. I suspect we're going to see more and more cases like that as reopening progresses, and the sort of particulars of reopening are subject to challenge.
And then the final thing we have on this slide, and this is sort of more of a thought experiment, but what claims might there be between the franchisees and the franchisor? We gave as a hypothetical here the most extreme situation with, which is that a franchisor might require all of its franchised units to close. And so we anticipated there might be claims for breach of contract, breach of the implied covenant, constructive termination, perhaps things like that. And on the slide, we've listed what we view as some defenses or justifications for that action by the franchisor. But of course, that theory could apply to a whole host of less extreme requirements, and really just illustrates the sort of tension between a franchisor wanting to have control over its brand and its goodwill and its trademarks, and the franchisee, on the other hand, having control over its individual business as an independent business owner. So we haven't seen any case decisions with this type of claim yet, but this is an issue that we see kind of potentially arising in the franchise context, in this pandemic state. So that, I believe, is all we have for you now. Thanks very much for giving us the opportunity to talk with you today.